Article 1545. For the obligation of either party to a contract of sale is subject to any condition which is not performed, such party may refuse to proceed with the contract or he may waive performance of the condition. So, dito po sinasabi na pwede nang hindi na lang tanggapin yung bagay or i-refuse na lang yung contract. If the other party has promised that the condition should happen or be performed, such first mentioned party may also treat the non-performance of the condition as a breach of warranty. So, dito naman po, pag di niya po na fulfill yung condition or hindi niya nagawa yung condition, this may treat as a breach of warranty. Pwede tawag natin na breach of warranty po. Where the ownership in the thing has not passed, the buyer may treat the fulfillment by the seller of his obligation to deliver that same as described and as warranted expressly or by implication in the sale, implication in the contract of sale as a condition of the obligation of the buyer to perform his promise to accept and pay for the thing. Dito naman po, pwede rin i-accept na lang ni vendee yung thing kahit na wala na po yung condition. So, ano nga ba ang condition? Sabi po dito, condition is used in Article 1455 means an uncertain event or contingency on the happening of which obligation or right of the contract depends in such a case. The obligation of the contract does not attach until the condition is performed. So, dito po, habang hindi nangyari ang condition, kung sino man po ang may obligation, ay hindi pa siya required i-perform. For example, B bought a laptop computer from S for 50,000, which B agreed to pay in cash provided that S had already installed an internet connection on the computer upon its delivery to him. S delivered to B's place with the internet connection not yet installed. What remedies are available? First, refuse to proceed with the contract. Ito po, pwede po niyang refuse na lang yung contract or hindi na lang tanggapin. He may also treat the non-performance of the condition as a breach of warranty. So, dito naman, dahil hindi natupad yung condition po, pwede niya pong i-accept na lang yung contract kahit wala na po yung condition. Magiging po siya ng breach of warranty. The second remedy is waive the performance of the condition. Ito po, tatanggapin na lang po niya yung contract or yung bagay kahit wala na yung condition. That's Article 1545.
Article 1546. Any affirmation of fact or any promise by the seller relating to the thing is an express warranty if the natural tendency of such affirmation or promise is to induce the buyer to purchase the same, and if the buyer purchases the thing relying thereon, no affirmation of the value of the thing, nor any statements purporting to be a statement of the seller's opinion only, shall be construed as a warranty unless the seller made such affirmation or statement as an expert and it was relied upon by the buyer. So, Article 1546, sinasabi niya dito na yung isa daw way ng seller sa pagbebenta ng product niya is to persuade the buyer na bilhin yung product na yon, and by telling the buyer ng things to assure na yung bagay na binibenta niya is worthy of its value, it is called express warranty, not a warranty, unless that the seller is an expert of what she or he is selling. Dun pala natin matatawag na warranty yon. But in this case, the seller's way to sell the product to the buyer is called express warranty. Pero, what is warranty? So, warranty, it is a collateral undertaking in a sale of either real or personal property, express or implied, that if the property sold does not possess certain incidents or qualities, the purchaser may either consider the sale void or claim damages for breach of warranty. So, yung warranty, yun nga, as being said na yung isang object or yung isang bagay na binibenta, kapag binenta siya sa'yo, meron siyang mga warranty in which ina-assure niya na yung product na ito, maayos siya, wala siyang damages, and magagamit mo siya dun sa kung saan mo siya dapat gamitin. And if hindi niya na-meet yung certain qualities na yon or yung certain design na yon for work na dapat gagamitin mo yung product na yon, pwede mong ireklamo si seller na yung bagay na binili mo is hindi siya naging useful para sa'yo and hindi niya na-meet kung ano yung dapat niyang paggamitan. So, yun yung warranty. So, ano naman yung express warranty? So, an express warranty is any affirmation of fact or any promise by the seller relating to the thing, the natural tendency of which is to induce the buyer to purchase the thing and the buyer thus purchase the same. So, ito nga express warranty, so ito nga sabi ko kanina is, ito yung way ng seller para ibenta niya yung product niya kay buyer. Ito yung sasabihin niya yung mga bagay na minsan hindi naman kapanipaniwala or opinion niya lang para mahikayat niya yung seller na bumili dun sa product na binibenta niya. Like, for example, merong isang tindera ng kotse. So, yung isang sales agent ng kotse, binibenta niya yung isang vintage car na lumang-luma pero napakaganda ng itsura niya for $90,000. And then, ang sabi niya sa'yo, yung product na binibenta niya is originally worth $100,000. So, ngayon ikaw, dahil nakita mo, ang ganda-ganda ang ganda-ganda ng sasakyan, tapos, nagustuhan mo siya kasi pwede mo siyang ipang-flex, ganyan. And maganda siya kapag magbabakasyon kayo, ganon. Kapag, alis kayo ng mga kaibigan mo or ng family mo, ganon. So, nakita mo na, yung sasakyan na yun, maggamit mo siya kasi sobrang ganda niya, tsaka bagay na bagay siya sa'yo, kasi kunyari, millennial ka, ganyan. So, ikaw naman, dahil ganun nga yung pagkakapansin mo and sabi sa'yo ni seller, uso yan, ganyan, maraming matutuwa kapag nakita nilang may ganyan ka, may higit sila sa'yo, ganun. So, dahil ikaw naman, naniwala ka doon, nagtiwala ka doon sinabi ng seller na yun nga, maganda yung kotse na binibili mo. So, ikaw niyan, papayag ka na bibilhin mo yung kotse na yon kasi maganda siya. Na hindi mo man lang tinesting, ganon, hindi mo man lang tinignan kung okay ba, basta pumayag ka na lang. So, binili mo siya, binayaran mo siya ng $90,000, and then, after ilang weeks, nalaman mo na yung car pala na yon, yung vintage car pala na yon, cost $80,000 lang. So, ikaw wala nang pananagutan si seller sa'yo na irereklamo mo siya for damages, wala siyang pananagutan doon dahil naniwala ka dun sinabi niya. So, yun yung epekto ng express warranty na sinasabi ng Article 1546. So, ano naman yung expression of opinion? So, yung expression of opinion, the usual exaggeration in trade when the other party had an opportunity to know the facts are not in themselves fraudulent. So, dito yun nga, yung express of opinion, yung binigyan ka ng opinion ng seller. Kahit na meron ka namang chance na malaman mo na yung product na yun, hindi naman talaga siya worth $100,000 or yung product na binibenta niya sa'yo is meron pang ibang mas maganda doon, binili mo pa rin, so hindi yun fraud, hindi ka niloloko ng seller kasi ikaw mismo, nagtiwala ka and ikaw mismo, pinili mo yung product in your own will. A mere expression of an opinion does not signify fraud unless made by an expert and the other party has relied on the former's special knowledge. So, yun nga. So, hindi yun fraud kung yung nagbibenta ng sasakyan or yung sales agent is hindi naman talaga siya expertise on that field or hindi naman talaga siya yung with degree na mapagkakatiwalaan mo na ito, professional to na may knowledge about cars, professional to na merong knowledge about doon sa binibenta niya. So, kung hindi naman ganun yung nagbebenta, so, hindi ka niya niloko kung sinasabi niya sa'yo yung mga bagay na maganda yung binibenta niya or what. So, parte kasi ng trabaho yun ng isang sales agent na sabihin sa customer niya na yung binibenta niya is maganda talaga. But that doesn't mean na nag-commit siya ng fraud against the buyer. So, a misinterpretation made in good faith is not fraudulent but may constitute error. So, yun nga, yung misinterpretation on the part ng buyer, so hindi yun kasalanan ng seller. Kasi, like nga, sinasabi nga paulit-ulit ng Article 1546 is, kapag pinagkatiwalaan mo na kung ano yung sinabi sa'yo ni seller, it's your own mistakes na. It's your own error na naniwala ka and it's your own free will na binili mo yung product.
Article 1547. In a contract of sale, unless a contrary intention appears, there is, number 1, an implied warranty on the part of the seller that he has a right to sell the thing at the time when the ownership is to pass, and that the buyer shall from that time have and enjoy the legal and peaceful possession of the thing. Number 2, an implied warranty that the thing shall be free from any hidden faults or defects, or any charge or encumbrance not declared or known to the buyer. This article shall not, however, be held to render liable a sheriff, auctioneer, mortgagee, pledgee, or other person professing to sell by virtue of authority in fact or law, for the sale of a thing in which a third person has a legal or equitable interest. So, an implied warranty is that which the law of derives by implication of inference from the nature of the transaction or the relative situation or circumstances of the parties respective of any intention of the seller to create it. So, ito naman, ito ay required by law unless waived by the parties. So, next, here are the implied warranties. Warranty against eviction, warranty against hidden defects, warranty of merchantability, warranty of that the thing purchased is fit for the purpose for which it was purchased. So, ito yung mga implied warranties. And implied warranties does not apply to the following. So, walang warranty against eviction, walang warranty against the hidden defects, walang warranty of merchantability, walang warranty of that the thing purchased is fit for the purpose for which it was purchased kapag ito ay binenta bilang. So, number 1, sale on as is where is basis. So, karaniwan ito yung mga bagay na second hand. Example nito is yung kotse or mga bahay. So, mga bahay na hinuhulugan sa bangko na hindi natuloy bayaran. So, as is where is basis ang mga yan. So, bilang buyer, ikaw na mag-i-inspect. So, titignan mo kung may mga defecto ba siya or may mga sira, and ikaw din magtitingin mismo kung may mga problema siya. So, next, sale of second-hand articles. And, so, pag second-hand, ito yung nagamit na ng iba. So, wala na siyang warranty and nasa sayo na kung bibilhin mo pa rin siya or hindi. Next, sale by virtue of authority in fact or in law. So, ibig sabihin nito, ito yung mga statutory sales. Yung mga nahatak na kotse na palagay mo binenta. So, in these instances, dito sa tatlong to, ang rule is caveat emptor. So, ang ibig sabihin nito ay buyer beware. Ibig sabihin, yung si buyer mismo ang magte-take ng risk. Siya yung mag-aalam kung bibilhin niya ba or hindi. Bakit? kasi wala ng warranty ang ibibigay ni seller.
Article 1548. Eviction shall take place whenever by a final judgment based on a right prior to the sale or an act imputable to the vendor. Ang eviction ay nangyayari sa final judgment. The vendor is deprived of the whole or a part of the thing purchased. Ito naman po ay, for example, nag-purchase sila ng land, it can be a whole or a part thing of the land. The vendor shall answer for the eviction even though nothing has been said in the contract on the subject. Natural elements po yung warranty. The vendor shall answer for the eviction. Contracting parties, however, may increase, diminish, or suppress this legal obligation of the vendor. Nasa choice ni vendee kung i-waive niya yung obligation ni vendor. Ano nga ba ang eviction? Eviction may be defined as the judicial process whereby the vendee is deprived of the whole or a part of the thing purchased by virtue of a final judgment based on the right prior to the sale or an act imputable to the vendor. For example, you are possessing into something na merong ibang taong gustong akuin or kunin yung bagay na yun, then as the judicial process, may mas right yung nakiklaim dahil doon may evict ka. What are the essential elements of warranty against eviction? So these are the essential elements. The essential elements are: first, the vendee is deprived in a whole or in a part of the thing purchased. So, you are deprived in the whole or part of the thing. Number 2, he is so deprived by virtue of a final judgment. Dito naman ay deprived siya ng final judgment sa korte. Number 3, the judgment is based on the right prior to the sale or an act imputable to the vendor. Dito may judgment na korte kung sino ang right prior. Number 4, the vendor was summoned in the suit for eviction at the instance of the vendee. And number 5, there is no waiver on the part of the vendee. Dahil nakapossess siya sa thing, masasama po siya sa court. And for example naman po is, S sells a parcel of land to B. Subsequently, C files an action for the recovery of possession claiming that he is the owner of the land. At the instance of B, S was summoned to defend his title. The court renders final judgment declaring that C has a better right Accordingly, B is evicted. So, S are liable for the B for failure to comply with this warranty against eviction, which the judgment is based on the right of a third person prior to the sale. So, si B, pwede niyang isue si S for damages because of the breach of warranty against eviction, the act of giving rise to C, right being imputable to the vendor.
Article 1549, the vendee need not appeal from the decision in order that the vendor may become liable for eviction. So, under this article, sabi, di mawawala yung rights ni vendee against kay vendor kahit hindi siya mag-appeal sa court or magpasa ng appeal sa court, basta nandun yung final requirement, which is yung court meron siyang final judgment or decision. For example, ako, as a vendee, tapos bumili si Kat yung vendor natin. Tapos si Tin naman yung third party. Ako and Kat, nagkaroon kami ng contract bumili ako ng bahay at lupa sa kanya. Then after tumira ako dun sa bahay at lupa na yon ng within 6 months. Tapos after 6 months, biglang dumating si Tin. Sabi niya sa akin, wala akong karapatang tumira dyan kasi sa kanya yung bahay at lupa. So, ang ginawa namin ni Tin, inakyat namin yung kaso sa court. Then, ang court, may final judgment siya na kay Tin nga yung bahay at lupa. So, ako as Vendy, meron akong karapatang mag-demand or kasuhan si Kat. Kasi liable siya for eviction kahit hindi na ako mag-appeal sa court.
Article 1550. When adverse possession had been commenced before the sale, but the prescriptive period is completed after the transfer, the vendor shall not be liable for eviction. In prescription, an individual can acquire ownership and other real rights in the completion of the prescriptive period under the conditions prescribed by the law. Under this article, there are two events: completed before sale and completed after sale. So, there is an illustration to easily understand the concept. The arrow represents the prescriptive period. So, under completed before sale, the prescriptive period is completed before nagkaroon ng sale. In this case, an individual acquire ownership and other real rights by prescription. So, in the sale, si seller nagbibigay siya ng warranty that assure the buyer that the seller has the right to sell and to transfer ownership. Then, the buyer will enjoy the legal and peaceful possession of the thing. But since the buyer is deprived of the thing, as the third person acquire ownership and other real rights by prescription, the seller is liable and the vendee can enforce warranty against eviction to the seller. Next is the completed after sale. Here, the prescriptive period is not yet completed, then there is a sale. In this case, wala pang na-acquire na ownership and other real rights si third person. So, si seller, hindi siya liable kay buyer even makomplete yung prescriptive period, since the remaining time before makomplete yung prescriptive period, the vendee can bring the necessary action against the third person to recover the property. So note that this article is not applicable to the land registered under torrent system, because under torrent system, ownership of land is not subject to prescription. So to better understand, let us have an illustration. S sold to B a parcel of land which is claimed by C, who has been in possession of the property in the concept of owner publicly and continuously for 30 years. Under the law, C is deemed to have acquired ownership over the land by prescription without need of title or of good faith. In this case, S shall be liable to B in case of eviction. So, in the example, the prescriptive period is already completed. So, nag-acquire na si C ng ownership and other real rights. And then, si seller, liable siya kay B in case of eviction. Next is an example of completed after sale. If in the same example, C was in adverse possession of the land for only 25 years at the time of the sale, and the prescriptive period is completed after the sale, S shall not be liable to B in case of eviction, as B could have brought action against C during the remaining 5 years period to recover the property. Here, the prescriptive period is not yet completed. So, 25 years. So, si C, hindi pa siya nag-a-acquire ng ownership and other real rights. Then, si seller hindi siya liable kay buyer since meron pang remaining 5-year period para ma-recover ni buyer yung property kay third person. Article 1551, if the property is sold for non-payment of taxes due and not made known to the vendee before the sale, the vendor is liable for eviction. 1551 discussed that at the time of sale, the non-payment of taxes was not known to the vendee. Then, if the vendee is deprived of the ownership of the property because of non-payment of taxes due from the vendor, liable si vendor for eviction.
Article 1552. The judgment debtor is also responsible for eviction in judicial sales unless it is otherwise decreed in the judgment. Article 1552, it tackles about the eviction and hidden defects that the judgment debtor is responsible for even in judicial sales unless otherwise decreed in the judgment. The general rule here is that if the judgment debtor has no right over the property subject to attachment, then he will be liable for the eviction of one who bought the property in a judicial sale. Exception, unless the court decreed otherwise. Like for example, si judgment debtor nagbenta siya ng lupa kay Z. Now yung lupa ay pinag-aawayan or pinag-aagawan po pala nila ni debtor at ni creditor. And while the land is being liquidated in court or nasa korte pa, binenta ni debtor yung land kay Z. Later on, natalo si debtor sa korte na yung totoong may-ari ng lupa or may karapatan sa lupa na yun ay si creditor pala. Upon the sales of the land, of course, nagbayad si Z kay debtor. And in this case, need ibalik ni debtor yung proceeds ng pagbenta ng land kay Z. And yun yung rule sa Article 1552. And also, Article 1552 is based on the general rule or general principle rather that a person may not enrich himself at the expense of another. Sa mga case na ganito, if the judgment debtor has no right over the property that has been sold, yung bumili or purchaser, may rights siya or is entitled to recover yung binayad niya with interest from the judgment debtor. Here, si judgment creditor naman, she is not permitted to retain the proceeds of the sale at the expense of the purchaser.
Article 1553. Any stipulation exempting the vendor from the obligation to answer for eviction shall be void if he acted in bad faith. So, dito naman, sinasabi ng Article 1553 is yung isang seller na nag-undergo ng warranty of eviction, hindi siya ma-exempt sa kahit anuman na punishment or decision ng jury kung nag-act siya in bad faith dun sa pagsisell ng product niya. Like for example, yung isang seller, alam na niya na yung isang seller na agent ng mga ng mga lupa, ganyan. So, alam niya na nabenta niya na yung lupang binibenta niya sa'yo. Pero binibenta niya pa rin sa'yo yung lupa na yon. So, kapag yung seller ay yung buyer nung product na yon or yung unang nakabili nung product na yon or nung land na yon is nagreklamo siya, yung seller is hindi siya ligtas sa kahit anuman na parusa na sasabihin or ipapatupad ng judge dahil alam niya na yung lupa na yon is nabenta niya na pero binenta niya pa rin sa'yo. So, paano naman kung dapat ma-exempt yung seller doon? Ma-exempt lang yung seller doon kung for example, dalawa silang agent tong lupa na yon. Tapos yung isang agent, binenta niya na yung lupa na yun sa iba, tapos hindi niya nasabi doon sa kasama niya, tapos yung kasama niya naman is binenta niya sa'yo, tapos binili mo, doon pa lang ma-exempt yung seller na nagbenta sa'yo in case na magreklamo ka man ng warrant for eviction. Dahil hindi niya alam na, wala siyang idea na yung binibenta niya palang lupa sa'yo is nabenta na dahil dalawa nga silang nagbibenta nun. So, yun yung Article 1553.
Article 1554 states that if the vendee has renounced the right to warranty in case of eviction, an eviction should take place. The vendor shall only pay the value which the thing sold had at the time of the eviction. Should the vendee have made the waiver with knowledge or the risk of eviction and assume its consequences, the vendor shall not be liable. In this article, we have two kinds of waiver of eviction, the consciente and intentionada. Consciente means a waiver that is voluntarily made by the vendee without the knowledge and assumption of the risk of eviction. Ibig sabihin, winaive niya ang warranty without knowing na may risk of eviction. Hindi siya aware na may problema pala ang thing. In that case, ang effect nun ay, the vendor shall pay only the value which the thing sold had at the time of eviction. While in intentionada, a waiver is made by the vendee with knowledge of risk of eviction and assumption of its consequences. Dito naman, aware si vendee na may risk of eviction. Alam niya or may knowledge siya na may problema yung thing. In that case, the vendor is exempted from the obligation to answer for eviction, provided he did not act in bad faith. If si vendor nag-act siya ng bad faith, then he will not be exempted from the obligation. Take note, every waiver is presumed to be consciente. Makakonsider lang siya as intentionada if na-prove nila na may knowledge si vendee.
Article 1555. When the warranty has been agreed upon or nothing has been stipulated on this point, in case eviction occurs, the vendee shall have the right to demand of the vendor, first, the return of the value which the thing sold had at the time of the eviction, be it greater or less than the price of the sale. So, if eviction occurs, si vendee meron siyang karapatan or pwede niyang i-demand si vendor na ibalik yung value nung thing or nung subject matter, whether it increase or decrease at the time of sale. Pwedeng nag-increase siya by improvement or nag-decrease siya by deterioration. Number 2, the income or fruits if he has been ordered to deliver them to the party who won the suit against him. So, for example, meron ng final decision ng court. Lumabas na wherein si third party nga yung may-ari nung isang property. Then, lahat ng income or fruits kailangan ibalik ni vendee dun sa nanalong party. So, liable si vendee na ibalik yung mga fruits and income kay third party, lalong-lalo na kapag in-order siya ng court na ibalik to mga to. 3. The cause of the suit which caused the eviction and in a proper case, those of the suit brought against the vendor for warranty. So, sa vendee, meron siyang karapatan or entitled, vendee is also entitled to recover the expense of litigation. Expense of litigation examples are the following: attorney's fee, court fee, professionals fee, yung mga ganon, na ma-incurred niya while defending himself in the action. Pero hindi naman lahat ng expense niya is ipapakargo niya kay vendor, tama. Merong mga expense na hindi nasagot ni vendor yon, like yung mga traveling expense niya, like papunta mula sa bahay, papuntang court, hindi nakasama yon. Hindi nasagot ni vendor yung mga yon. Number 4, expenses of the contract. In the absence of any stipulation to the contract, yung mga expenses in execution and registration of the sale, si vendor ang magbo-borne. However, kunyari si vendee ang nagbayad lahat sa pagre-register nung sale and other execution, then si vendee meron siyang right to demand kay vendor para ma-recover niya lahat ng nagastos niya through the contract. Last is yung damages and interest. The right of the vendee to demand damages and interest and ornamental expenses is qualified by the condition that the sale was made in bad faith. Pero kung yung kung yung sale is made or good faith siya, si vendor in good faith siya, then si vendee, wala na siyang right to demand for damages and interest kasi in good faith si vendor.
Article 1556, should the vendee lose by reason of the eviction a part of things sold of such importance in a relation to the whole that he will not have bought it without said part, he might demand rescission of the contract, but with the obligation to return the thing without other encumbrances than those which it had when he acquired it. He might exercise this right of action instead of enforcing the vendor's liability for eviction. The same rule shall be observed when two or more things have jointly sold for lump sum or for separate price for each of them, if it should clearly appear that the vendee would not have purchased one without the other. In this article, it talks about rights of vendee in case of partial eviction. Kung partial eviction siya, may option si vendee na i-enforce yung liability ni vendor for eviction or he might demand rescission of the contract. Para ma-exercise niya yung dalawang rights na yon, dapat mamimit niya yung sasabihin ko. When the vendee is deprived of a part of thing sold if such part of such importance to the whole that he would not have bought the thing without said part. Meaning yung part na na-evict ay importante siya doon sa kabuuan ng thing. Kapag nawala yon, hindi bibilhin ni vendee yung thing. Tapos, when two or more things are jointly sold whether for lump sum or for separate price for each, and the vendee would not have purchased one without the other. Example, si S sells to B a parcel of land represented by S as containing 500 square meters at the rate of 200 per square meter. B needs a lot at least 500 square meters on which to build a factory. B is evicted from 200 square meters portion of the land. B would not have bought the land had he known of its smaller area. Under the facts, B can either sue for damages for breach of warranty or demand rescission of the contract. He can also exercise his alternative rights if these two parcels of land sold and he should lose one of them by reason of eviction. Kasi kailangan ni B ay 500 square meters para dun sa factory niya. If alam lang daw ni B na 480 square meters lang yung land, hindi niya bibilhin. Ibig sabihin, yung 20 square meters na na-evict or nawala, ay importante siya dun sa kabuuan. Therefore, he can exercise the rights that was mentioned. Tapos, in case naman sa totally evicted, he cannot avail of the remedy of rescission. Kasi yung remedy na sinasabi kanina, kailangan ibalik ni vendee yung mga kung ano man ang na-receive niya. This is not so when the vendee loses only a part of thing sold because there still remains a portion of thing. In case of rescission, the vendee can return the thing, but it must not be subjected to other encumbrances than those which it had when he acquired it.
Article 1557. The warranty cannot be enforced until a final judgment has been rendered, whereby the vendee loses the thing acquired or a part thereof. So, ito yung mga other requirements to enforce the warranty against eviction. So, number 1, deprivation in whole or in part of the thing sold. Number 2, existence of a final judgment. Number 3, formal summons to the vendor. Number 4, vendor to be made co-defendant.
Article 1558. The vendor shall not be obliged to make good the proper warranty unless he is summoned in the suit for eviction at the instance of the vendee. Well, another essential requisite kasi here is that bago maging legally liable si vendor for eviction, he should be summoned muna in the suit for eviction at the instance of the vendee. Yung phrase sa Article 1558 na unless he is summoned in the suit for eviction, it means lang na si Vendy, isasummon niya si vendor para maging co-defendant niya by filing of a third-party complaint against the said vendor. The case here kasi is that si third party na nag-file ng action for recovery ownership, ang gagawin niyang defendant dito is si Vendy kasi siya yung may possession ng lupa eh. Now, para matulungan si Vendy, ang gagawin ni Vendy, since nakuha niya lang yung lupa kay vendor or yung rights na meron siya or yung rights na na-transfer sa kanya galing kay vendor, isasamon niya si vendor as co-defendant niya. What is the objective of the law? Bakit may ganon? Well, the objective of the law is to give the vendor an opportunity to intervene and defend the title that he has transferred. Bakit nga pang ganon? Para malaman niya yung circumstances or yung reasons behind the claim of the plaintiff and be in a position para ma-defend niya yung validity of his title. And in the absence of such opportunity, the vendor is not bound to his warranty.
Article 1559. The defendant Vendy shall ask, within the time fixed in the rules of court for answering the complaint, that the Vendy be made a co-defendant. This article refers to a case that deprived the Vendy from the purchased thing. So in this case, the defendant, which is the Vendy who wants to preserve his right of warranty, may ask the court to call the vendor, and within the time fixed on the court, made him co-defendant to answer the complaint of the plaintiff who seek to deprive him from the property purchased.
Article 1560. If the immovable sold should be encumbered with any non-apparent burden or servitude not mentioned in the agreement of such a nature that it must be presumed that the vendee would not have acquired it had they been aware thereof, he may ask for the rescission of the contract unless he should prefer the appropriate indemnity. Neither right can be exercised if the non-apparent burden or servitude is recorded in the registry of property unless there is an express warranty that the thing is free from all burdens and encumbrance. Within 1 year to be computed from the execution of the deed, the vendee may bring the action for rescission or sue for damages. 1 year having elapsed, he may only bring an action for damages within an equal period to be counted from the date on which he discovered the burden or servitude. So, dito naman, sa Article 1560, so, balik ulit tayo sa mga real estate agents, sa mga nagbibenta ng lupa. So, for example, may nagbibenta sa'yo ng lupa, and yung binibenta niyang lupa, ang sabi niya sa'yo is 1,000 square meters yung sukat niya. Pero, hindi naman yon yung talagang pag-aari mo. It turns out, yung pag-aari mo pala, yung binili mo pala sa kanya is 900 square meters lang yung laki. So, pwede mong ireklamo yon and pwede kang mag-file ng warrant for eviction and pwede mong sabihin na yung pinenta sa'yo, yung pinagkasunduan nyo is 100 square meters, pero inukuha mo lang is 900 square meters. So, pwede mong ireklamo yon sa judge. Pero, kung yung property na yon na mistakenly is nasukat pala siya na 100 square meters and nasa registry of property siya na 100 square meters yung sukat niya, kahit na pinasukat mo yon and yung sukat niya is 900 square meters, hindi ka pwedeng mag-file for damages dahil nandun nga siya sa registry of property. So, pwede ka lang magsabi na na may nangyaring anomalies if wala siya sa registry of property. So, paano naman na makakapag-file ka for damages? So, makakapag-file ka for damages if ipapregister mo na yung lumang binili mo is 900 square meters lang. So, pwede mong i-file yun sa registry of property and then, pwede mong kasuhan within 1 year period for damages or for cancellation of contract of sale yung seller. Pero kapag lumagpas na ng 1 year or kapag yung period na ng pag-file mo ng case is lumagpas na sa 1 year, pwede ka nalang mag-file for damages, hindi mo na pwedeng i-cancel yung contract of sale. So, yun yung Article 1560.